Start. Sir, I fully agree with the feelings and sentiments expressed by the honorable members that more is required to be done so far as senior workers are concerned. I have not stated in my speech, nor that is the purpose or the object of that this is what is possible or everything has been given by this amendment. Sir, the step which has been proposed and which appears from the statement of objects and reasons is to bring the senior workers at par with others similarly situated on equal footing. There are four acts under which this welfare fund is in operation. So it was thought by the government first to bring the senior workers at par with them when their welfare fund is being exercised within certain parameters, and the same would be brought so far as senior workers are concerned, and that is why these amendments are being made to bring it at par with them para. The honorable members suggested that it should not be rupees 1600 but it should be more. But at present under other acts it is remaining at rupees 1600, but senior workers has remained at rupees 1000. So we wanted to bring them on equal footing with others, and so far as the question of its raising further is concerned, those are the exercises which are required to be made later on. Firstly, we wanted to bring this social legislation, the beneficial legislation, as quickly as possible to the benefit of senior workers para. Sir, so far as what has been given up till now is concerned, immediately this was transferred from the Information and Broadcasting Ministry to the Labour Department in April 1986. This discussion took place as to how the benefit is to be given. It was identified that under other welfare funds there are 11 hospitals and 213 dispensaries which have been directed to give the same benefit which were being given by the other welfare fund covering other workers to the senior workers. So immediately the workers who are nearby to these hospitals and dispensaries in the country will get the benefit para. An honorable member said that there are minors working and it should be checked. So far as that is concerned, there are other acts which come into operation for the protection to the minors. So far as theatres are concerned, there is a special act. As you know, it is the Cinema Theatre Employees Regulation of Employment Act that will govern the position. Guidelines will certainly be framed as soon as the bill comes through. There will be checks, balances and guidelines for the rule making power. The government will not have unbridled power, but it will have powers which are controlled by various checks and balances. So far as the expenditure is concerned, I find that rupees 1 lakh has been given as a scholarship for the people who are children of the workers. Here stop. The Labor Department is taking action. Para. Mr. Vice Chairman, the question that has been posed in this bill is very simple. The facts to which the question is posed are simpler. The fact is that there has been a slight increase in the pending cases. Please mark the word slight. The question is that 3 judges are necessary for this. This is what we are going to consider today. The constitution makers in the year 1949 thought it wise to provide that the Supreme Court should have 7 judges in all, excluding the Chief Justice of India. It was in 1956, 7 years later, that the number was raised from 7 to 10. It was argued then that Article 145 of the Constitution required that the Constitution bench should consist of 5 judges, and therefore it was not possible to run the Supreme Court with 8 judges in all. Stop. I would only submit, without going into further arguments, that the Constitution makers, while incorporating Article 124, must have looked into the provision of Article 145, and while incorporating Article 145, they must have also looked into the provisions of Article 124 when the number was increased to 10. Now we are being asked to increase it to 13. I have no objection if for a proper disposal of the cases, for a speedy disposal of the cases, because I am well aware of the principle that justice delayed is justice denied. Instead of 3, even if 10 or 15 judges are necessary for the Supreme Court, they should be given. But the question is, in view of the facts that are there, is it actually necessary? Para. The Law Commission, which consisted of many experts in the country, experts in the profession, many retired judges, opined after taking all facts into consideration that for the present the number of judges should not be increased, and in order to deal more effectively with the pending cases, they suggested certain remedies. May I ask the Home Minister why the remedies that were suggested by the Law Commission have not been tried so far? For example, they have said it has been argued in detail, and therefore I will not go into it at length, that the Supreme Court is at present being charged with labor appeals, and that some machinery should be provided, some provision should be made in the different laws so that appeals flow to the High Courts, or a specially constituted tribunal can be provided so that the cases in the Supreme Court will be lessened. Stop. It is not because we have argued at length about Article 136 of the Constitution. The Law Commission have not gone into it at length. They want Article 136 to be there as it is. All that they mean is that if a provision for appeal is provided in the Labour Act, many of the cases will not be coming to the Supreme Court. Stop.